Can you imagine paying for your dream home, almost the entire amount, and then waiting 15 long years? Not to move in, but just for a final decision on whether you'll ever get the keys? Well, that's exactly the story of the Nehra family's incredible journey through the legal system, a fight that went all the way to the Supreme Court.
Welcome to today's case law discussion on Amit, Nehra versus Pawa and Garg. This is presented by Scoot Legal Translation and Transcription Services, your trusted partner for accurate and confidential multilingual legal documentation.
Okay, just look at this timeline. It really lays out the sheer scale of the Nehra family's ordeal. It all started so simply, with an apartment booking way back in 2010. But as you can see, it took until 2025 for the Supreme Court to finally deliver a verdict. That's a 15-year wait for a home they had already paid for. Just incredible.
So let's start at the very beginning. Back in 2010, the Nehra family booked what they thought would be their dream apartment. It was in the Area Rise project in Mohali. You know, it's a story that's probably familiar to many of you, filled with hope and the promise of a new beginning.
And they didn't just dream, they backed it up with their life savings, paying this staggering amount, over 57 lakh rupees. That was pretty much the entire sale price. So from their side, the deal was done. The bargain was fulfilled. The promised possession date of 2013 came and went. But then, in 2018, things got a whole lot more complicated. The builder, MS Puma Realtors, went into insolvency proceedings, and that changed everything for the Nehra family's fight.
So, the company entered what's called the Corporate Insolvency Resolution Process, or CIRP. What is that, you ask? Well, you can think of it as a legal rescue plan for a company that's in deep financial trouble. An outside professional comes in to manage everything and sort out all the claims from creditors, including homebuyers like the Nehras.
Now, because of this new process, the Nehras had to formally file a claim to get their home. And folks, this is where the central dispute of the entire case comes from, the simple but critical timing of that claim.
So here's the real heart of the dispute. On one side, you have the Nehras, who insisted they filed their claim on time way back in January 2019. But on the other side, the builder's new management just flatly denied this. They said the only claim they ever got was in February 2020. And get this, that was after the big rescue plan was already approved. The Nehras pointed to a simple fact. Their claim was officially verified and listed, but the builder's management argued that because it was late, the Nehras weren't entitled to the apartment, only a 50% refund.
And you know what? At first, the system really seemed to fail them. Two specialized tribunals for company law matters, the NCLT and then the NCLOT, both sided with the builder. They ruled that the Nehra's claim was, in fact, late. This meant no home, just a partial refund. A devastating blow. So after losing not once but twice, the Nehras took their fight all the way to the top, to the Supreme Court. The highest court in the land had to cut through all the arguments and answer one really central question. And that question was this: can a claim that has been officially accepted and verified just be thrown out because of a fight over when it was filed, especially when a family had already paid for almost the entire thing? The Supreme Court did something brilliant. They decided to look past all that back and forth about the filing date. In their view, that wasn't the real issue here. What truly mattered was that the resolution professional had officially verified the Nehra's claim and put it on the final published list of creditors. It was on the books, period.
You see, this whole case really boiled down to two little clauses in the builder's rescue plan. The first was for homebuyers with verified claims. They would get their apartment. Simple. But the second clause was for those with unverified or late claims, and they would only get a 50% refund. The Supreme Court just had to decide which box the Nehras fit into. Their entire future hung on that distinction.
And this quote from the judgment, wow, it just perfectly captures the court's logic. They said that ignoring an officially admitted claim isn't preserving the plan, it's misapplying it. For the court, the fact that the claim had been verified and was on the list was the absolute deciding factor. Now, the court wasn't just pulling this out of thin air. Their decision was actually backed up by a really important precedent, a legal principle from a previous case that offers another layer of protection for homebuyers.
It's known as the Puneet-Kaur principle. And what it basically says is this: if a company's own records show they owe someone money, like the builder's records showing all the Nehra's payments, that claim can't just be ignored over a technicality. The key point is the company already knew about the debt.
So, with all of this in mind, the verified claim, the specific clauses of the plan, and that key precedent,
the Supreme Court was ready to deliver its final and truly landmark verdict.
And the court's directions? They were crystal clear. No room for argument. First, they canceled the orders from the lower tribunals. Second, they ordered the builder to execute the deed for the apartment. And most importantly, they ordered the builder to hand over physical possession of the home to the Nehra family within 2 months.
So why does this one family's story matter so much to everyone else? Well, it's a huge deal. The Supreme Court's judgment provides a crucial safeguard for all genuine homebuyers who get caught in these complicated insolvency cases. It confirms that an officially verified claim can't be easily dismissed, and it stops rescue plans from being twisted to deny people their rightful property. This is a powerful precedent for so many cases to come.
You know, the Nehra family finally got the justice they deserved, but their 15-year struggle, it leaves us with a really important question to think about for the future. How can the system be improved so that homebuyers don't have to go through an ordeal like this in the first place?
Today's case law discussion was brought to you by Scoot Legal Translation and Transcription Services, your trusted experts in multilingual legal documentation for practicing advocates. This audio is created with assistance of Notebook LM.